asked a really important question, and you got into this, some of this, but about the politicization of the court, and you know, over time, the influence of political parties on the court, and you know, are we at a breaking point with that? I think that's the tone of some of the other questions.
Yeah, I think, and again, one of the things, and how do you make this stuff interesting for your students? Because it's otherwise just, now, who cares, right? Tell me something I need to memorize and I'll crank back on an exam, right? Part of what makes this period so interesting is not only the creation of an enormous federal power, but it's also the fact that politics has long been a part of judicial and constitutional law. It ebbs sometimes, it flows at other times. Think about the period up to the Civil War and Dred Scott, and the decision that Tawney thought, because he thought judicial power was so robust and the other institutions were so delegitimized, that the Supreme Court could settle the sectionalism problem and the slavery problem. So he rendered the decision in Dred Scott, which is a 7-2 decision, because by this time Marshall's long gone and you got a bunch of Jacksonian, et cetera, appointees to the court. But those people were favorable to slavery, and so they bought off on Dred Scott. You see this kind of context or conflict around the New Deal and economic regulation and the crisis that brought about the switch in time that saved nine. You're seeing it today. And you're seeing the battle waged in a much more intensely partisan way than in our lifetimes, although not in previous lifetimes, okay? But in our lifetimes, because of the polarization of political parties. And so when Donald Trump says that John Roberts is a liberal, anybody who knows John Roberts must just cringe and or laugh hysterically, because this is a guy who came through, influenced by the Heritage Foundation, Federalist Society. He was in Ronald Reagan's Justice Department. But Trump yesterday tweeted out, I think he tweeted like this, I've never tweeted, but Trump tweeted out that the Supreme Court must not like him, and said, you know, this is another reason to vote for me in 2020. So this relationship is of a piece of what we've seen in the past. It's just a little bit more intense.
I think that's a great answer. And I think you answered another popular question was from Alfonso Weems about whether we're repeating history. And in a sense, you know, history rhymes. I think we're always repeating it to a certain extent, but I think you pointed out some ways that we are also kind of on new ground, or, you know, our own territory right now. There's a request that I think we can follow up on to recommend some books that you think would be great, and we could do this during the break, and we can share maybe some books on the chat that you recommend.
Will do.
John McCusker raises an issue that actually goes back to something I talked about on Wednesday with the Kentucky and Virginia resolves, that the issue of nullification and judicial review. Can you talk a little bit? This is kind of an interesting issue, how it was kind of up for grabs. This idea of judicial review, that, you know, the first vetoes that presidents had were in a sense kind of like judicial review. They would veto laws that they thought were unconstitutional, and so maybe talk about some other competing, you know, paths to that.
Well, and again, this is Jefferson's reaction to Marbury v. Madison. And initially the Jeffersonians like, you know, great, the court has decided in our favor because it's not making us telling us to give Marbury his commission. But Jefferson pretty quickly figured out that this was an enormous power grab on the part of Marshall. And as I say, he was PO'd because there was really nothing he could do to stop it, right? Jefferson believed that each branch made for itself the decision of whether or not something was constitutional. Congress would make that decision in the first instance in passing the legislation. The president would make that decision in whether or not to veto the legislation. But those things are written into the Constitution. They're not implied, right? You know that the president can veto because of Article 1, Section 7. So those are not implied powers. Jefferson was furious, and, you know, understandably so, that Marshall took a vague phrase like judicial power and blew into it the implied authority of judicial review, much like Washington took the vague phrase executive power and assumed a sense of executive privilege. That's not written in the Constitution either. Now, the question, I'm trying to connect Marbury v. Madison to Virginia and Kentucky resolutions. If you are a states' rights person, okay, and Jefferson, I would argue, and Denver can correct me because he knows more about Jefferson certainly than I do. Jefferson was more of a states' rightser than Madison was. And Jefferson wrote the Kentucky resolutions, and those pretty much are states can nullify federal law. The Virginia resolutions don't go that far. They, in my recall of them, it's been a long time since I've written on this, but in my recall of them, they basically argue that acts of the federal government, alien sedition among them, were unconstitutional. But they're instructing the Senate to take action to repeal them. Okay, they're appealing to states in the constitutional body that represents states, which is the Senate. So yeah, that's an appeal to the governmental institutions to undo an error. Jefferson's suggests a separate sort of source of sovereignty that would have the capacity to veto. So in a sense, it's who gets to say no? Who gets to enforce the limits on the Constitution? And there's nothing in the Constitution in particular that assigns that authority. And again, part of the genius of Marshall is creating this power in a context where his party is dead. I mean, the last secessionists until the Civil War were the New England Federalists. They wanted to leave the Union around the time of the War of 1812, right? Marshall rides this thing through, and then as Republicans get more authority, the federal government doesn't look so scary after all because we have the power, and we're not going to abuse power. So,
yeah. Well, I think a nice follow-up comes from Selena Garcia, and she asked a good question. You talked about how judicial review is written into certain state constitutions, and it's in the Federalist Papers. Why not Article 3? Why do you think that the framers didn't include it more explicitly?
There were in the original Virginia draft, Madison's model constitution, and when I've talked, some of you folks may have heard me talk about the Constitution. Part of Madison's genius was he knew that if you want to get your way, you set the agenda, and that's what the Virginia plan did at the Constitutional Convention. There was a Council of Revision in the original Virginia plan, and that would have had a combination of justices of the Supreme Court and the president making a decision not only on federal law, but more significantly on state laws. It would have given the national government a veto over state laws, which is something that, again, distinguishes Jefferson and Madison quite prominently. That got dropped, in part because of the shifting politics of the convention, and in part because they weren't really worried about judicial power per se, because all the powers in the legislature. Part of the reason why Article 2 is so short, in part because Washington's sitting there at the convention, everybody knows he's going to be the president and he's cool, but also because they had, the people who pushed for the Constitution were reeling from what they saw as excessive legislative power in the states and weaknesses in the federal government to deal with that. And so they talk about limiting legislative authority. The only branch of the federal government that's broken against itself is the Congress. And the whole point of that, and you read the Federalist Papers, the Senate is to check the House, to make sure that the popular will doesn't go berserk and start abusing governmental power. So they were really concerned with those kinds of questions. And those kinds of questions tied to things like slavery, comparative authority of the states, and the like. And so the courts were almost an afterthought. And again, the first 10 years, they couldn't keep people on the Supreme Court.
Excellent, excellent. So I think this is a good question. Michael Kraft asks, for the unenlightened, can you explain the significance of writs of mandamus?
And this is the hardest part for me when I teach Marbury, because all writ of mandamus is a formal order to a governmental official to do what he or she is supposed to do. And so in this instance, Marbury sued for a writ of mandamus because he wanted Madison to give him his commission. Marbury wasn't about Marbury, the guy, William Marbury, wasn't about grand constitutional principles. He wanted the job of Justice of the Peace for 5 years in Georgetown so that he could collect tax or fees from people like Denver. Okay, it was a nice supplement to his attorney income. So that's why he sued. So he sues Madison saying, "Give me my commission. It's been signed and sealed." It's a partial Stevie Wonder. It's been signed by the president, sealed by the Secretary of State, but it's not been delivered. Deliver the commission. That's what the mandamus would do. Congress gave the power to issue writs of mandamus to the Supreme Court in the Judiciary Act because no one really knew what the Supreme Court was going to be doing, so it might as well do something. It might as well issue writs of mandamus, right? Marshall's genius is to say that's unconstitutional. And he does it in a way so that Jefferson gets what he wants. He's not ordered to give Marbury his commission, but Marshall gets what he wants, which is power. Secretary of State or Treasury? Let's do it, right?
So we have time for a couple more, and then we'll try to fold some of these into the document session. Mary Bailey's actually has a few good questions on the board, but why don't we go with the one about writing circuits? And can you talk a little bit more about how that worked, especially if they were supposed to be located in Washington? How often were they actually in the district versus outside of it?
Very seldom, especially early on, because there wasn't a lot of litigation coming up on the federal level. And so they met the first time in the Royal Exchange building in New York and realized they don't have a permanent home. I mean, they just sort of floating around. They go from New York to, were they in New York for a while?
Yep.
They don't have a building or anything. So they would meet for their term and they'd hear the handful of cases that there might be. But the rest of the time, they're out on the road, sitting on these circuit courts. And again, part of this is context, and you can play with this with your kids. It's not like you're going to pull over to an Arby's, right? Assuming that you're going to eat Arby's. But it's not like you're going to pull over to an Arby's. And it's not like there is a DoubleTree or a Comfort Inn or something like that you're going to stay at. When you're out on the road, you got to look for places where you can stay. Oftentimes it's in taverns and inns where people yell huzzah and sing drinking songs. And the food probably isn't all that great. And the rooms are probably multi-person rooms with bed bugs and stuff like that. It's just not pleasant. Justice Chase, who the Federalists tried to impeach, Justice Chase was once riding circuit, and it was somewhere in the Northeast in the winter. And his carriage broke through, they were going over a river or a lake. It broke through the lake, and his carriage and he actually were submerged, and he almost died. Imagine if you're a justice and you're going down to Georgia to sit in the summer on a court of appeals. It's not fun, right? And so that's what they did. And Marshall was willing to suck that up because he had a big plan. And again, that bigger plan is informed by, and it's not to say that Marshall was wholly political. He had a legal constitutional philosophy, which he read into the Constitution through his decisions. But he was playing the long game. He was playing to infuse Federalist principles into a document that was no longer going, or establish a government that was no longer going to be controlled by Federalists.
Absolutely. And one last quick one. I think we talked about this briefly, and it's a really interesting connection that Jefferson and Marshall were cousins.
Yeah.
And how much did sort of personal, familial rivalry play into their political rivalry?
I don't know the personal rivalry well enough. They despised one another. But I despise my children. I still love them. That's a joke. I think really what it was is that they had sufficiently different conceptions of government and governance. And they both came up through Virginia. They were second cousins, I think. So they were well aware of one another. Marshall's substantially younger than Jefferson. He took over as Chief Justice in his early 40s, I believe. But they had substantially different visions of governance, and they had bumped heads prior to Marshall going to the Supreme Court. And again, part of the thing that makes Marbury v. Madison so cool is that who failed to get Marbury his commission? The current Secretary of State. And who was the current Secretary of State under Adams? John Marshall. So Marshall failed to get Marbury his commission, and yet writes the opinion in the case that decides whether Marbury should have gotten his commission. That's genius. I mean, today you'd have to recuse yourself, but Marshall just finessed all of this stuff, and he got away with it.
It was a small country.
Yeah.
Terrific.